Hello, my name is Jason Roth. I'm an attorney with the law firm of Roth Davies. I want to talk to you briefly today about going to trial. In a personal injury case, it's important to hire a lawyer that has trial experience with your particular type of case. So one of the things that you want to ask your attorney is, have you actually taken a case like this to trial? If you've decided to go to trial, that means that you've gone through all of the discovery and gone through a failed mediation. And so the concept is you're going to allow citizens of the community that you're in decide the dispute. The right to a jury trial is an important right. It was established by the 7th Amendment of the Constitution, and it is a right to have a jury hear your case and decide the case on the merits. The first thing that you do at trial is pick a fair and impartial jury. The idea is that you want to have members on the jury who have no preconceived notions or beliefs regarding your specific case or the issues in your specific case. In essence, you want the scales of justice to be even at the start of the case. So you go through a process of jury selection. The attorneys will ask the panel of jurors a number of questions to flush out any ideas or thoughts or prejudices or preconceived beliefs or notions in an attempt to pick the best, most fair and impartial jury. After jury selection, the attorneys will give their opening statements. During the opening statements, an attorney is not supposed to argue the case. Rather, the attorney is supposed to provide a roadmap, so to speak, of the evidence and what he or she believes the evidence will be from the stand in the case. After opening statements are given, where you preview the evidence, then the plaintiff goes first. Since the plaintiff has the burden of proof in a case, the plaintiff provides evidence, and that will be testimony or documents, typically medical records, employment records, those types of things, substantiating the plaintiff's claim. The plaintiff will likely call witnesses to whatever the event was. If there's an investigating officer, perhaps the investigating officer will be called. A doctor or two will likely be called at trial, if not many doctors, depending on the nature and extent of the injuries. After the plaintiff has rested, the defendant has the opportunity to present evidence that the defense lawyer believes is helpful to him or her. After all of the evidence is in, the attorneys will give a closing argument. In closing arguments, the attorneys will summarize the evidence and how they believe the evidence reflects on the issues in the case. If you have any questions regarding a personal injury case or taking your case to trial, please don't hesitate to call me at 913-451-9505. Thank you.